An Anton Pillar order is simply a search order or subpoena issued by the courts which allow parties to request information they currently do not have. This seems simple enough, right? The plaintiff approaches the court, has the order issued, demands the documents, and the court process continues. Sadly, the judicial system is not a perfect crime novel, where everyone does what they're supposed to do. Let's look at this further. Named after the case of Anton Pillar KG and Manufacturing Processes Ltd, an Anton Pillar order allows a court to give power to an independent solicitor to literally go into a defendant's premises and seize documents relevant to the case. Why would a court allow this? As mentioned earlier, court processes are not like a perfect crime novel, where all the evidence is right there in front of the detective. Most of the time, evidence in cases has to be searched for. Consider when a defendant is notified they are being sued. Sometimes, if a defendant believes that they have a significant chance of receiving a penalty from the court, some defendants may attempt to destroy incriminating evidence before it's discovered. Although not all defendants do this, there is a real risk that this could occur. For a court to allow an Anton Pillar order to be granted, the following prerequisites have to be met. A strong prima facie case against the defendant, meaning that on first impression, there is strong evidence that the defendant has used the information in their possession in an incorrect manner. Evidence of actual damage or the possibility of actual damage if the materials were used in an adverse way, and clear evidence that the defendant has evidence that is incriminating and there is a very real possibility of the destruction of said evidence. The courts will not just grant an order based on the word of the plaintiff. Other evidence needs to be submitted to strengthen the case, such as reasons for the order, description of the categories of materials sought, address of the search, damage suffered by the applicant, details of the independent solicitor to be part of the search party, along with many other factors. Why then are these orders so important in intellectual property cases? As you can imagine, with the rapid development of technology, it's becoming easier and easier to copy or steal information. As information is so easily copied, it is also quickly deleted. An Anton Pillar order is a form of interlocutory injunction or stop order, but it is often granted very quickly, preventing the defendant from destroying materials which are pertinent to the case. There are certain limits on these orders. The defendant can attempt to refuse entry, however the court will take this as a sign of guilt. The court will also give consideration to the persons living at the residential premises that may be searched, in case of impacting on vulnerable people. Orders can include special provisions to ease the impact on these vulnerable people. After the documents and other relevant material have been seized, it is not usual practice for the plaintiff themselves to inspect the evidence. The evidence is given to the courts for examination. These searches generally occur between 9 a.m. and 2 p.m. on any given business day. Although we cannot predict the future nature of cases, we do know that technology is ever-changing. As technology changes, it is impossible to know how this will impact on the courts and the granting of Anton Pillar orders.